Okay. A grantor, settlor, trustor, or exchanger. These are all titles of someone or an entity that grants property or property rights to someone or another entity. A trustee is the person who agrees to manage the trust and take on its duties and assignments. They're also called fiduciaries. A beneficiary, the person who receives the benefit or beneficial use of trust assets or a future beneficial interest. A trust is used to accumulate wealth, protect assets, and limit liability. Operates sort of like an LLC, or that portion of a trust operates similar to an LLC without the C. Now, remind you, this would also give you an indication of the power of trust, because a limited liability company is basically a company that has one aspect of the trust, and that's the ability to limit the liability of the trustees of the company, or the board of trustees, the shareholders. Two means of trust formation are implied, that is by action, and express, oral or written. The two jurisdictions are private, also called common law or foreign, without the United States, and public, also called domestic and statutory, within the United States. Title split. Okay, the reason the grantor must give the property to the trustee is to split title. When you own anything outright, you have legal and equitable title. You don't have a trust. So anything you own that doesn't belong to anyone else, or no one else has a claim to it, you have the legal and equitable title. You're the owner. There's no title there, which should give you an indication that if you own a house or a car and someone else can stake a claim on it, i.e., they can come repossess it, then you don't have. There's a trust there, right? So if you're driving a car and if you don't make the payments, i.e., if you don't abide by the trust rules, the trustee can come snatch that car from you. All right. This is what I'm talking about when I tell you that trust is intertwined in all of our lives. Uh, a little bit known to us. All right. Well, to some of us, to some other people, because I know it, and once you get done with this course, you'll know it. um, Legal title is when you own property. Equitable title is when you use the property. They are inherently one and the same when you own something. All right. So, for example, if you buy a house and you rent it out, you split the title, and now someone else has the equitable rights to use your property. So, if you have a house, if any of you out there own property, what you've done when you've rented that property out is you've given equitable title to the renter. Okay. Now a trust is formed. And it is called a rent contract or a lease contract, rental agreement, whatever the case may be. That is the trust. And whatever provisions you have on that rental lease to let them know what they can and cannot do, those are the indentures. All right, so this should be coming clearer and clearer as we go along. This also happens when the DMV gives you the certificate of title to your car when they actually possess the title. All right. The certificate of title you get for your car is not the title. It is a certificate of title. And I'm going to tell you something right now. The English language is very loaded. The word of does not mean necessarily that it's speaking of something. So when you say the certificate of title, of means from. So that is a certificate from the original title. All right, I don't want to get too far into that. But they split titles and form a trust with you without you knowing it. So again, this is why even if you buy a car, so let's say you buy a car outright and you're not making payments on it, you have the certificate of title. Well, who can come and take your car? The state can. The IRS can. Because it's not really yours. You don't hold legal title to it. Right? Now, if you put it in a trust, then they can't take it because the trust has the title to it and it doesn't belong to you. Whatever action they're moving against you for, that has nothing to do with the trust. However, the judicial system of your state is the trustee of the real title of your car, which is called I forgot what it's called, the manufacturer statement of origin. I think this is the MSO, and that is when the car is created or is imported into the U.S. That MSO title is the original title. The DMV keeps that, or the state keeps that. When you register the car, you give them that legal title of ownership. You get equitable title, which is the certificate of title. All right, so I don't want to go too deep into that, but yeah, that's how a title is split, and that is how the state can come take your car, even though it's paid for. They can tow it and then keep it, and a whole host of other things. Now, to further expound upon this issue of title, we're going to go to this link here. All right, and let me connect to the internet. Give me a second here. All right. So now, here we have the merger doctrine, or some people call it the doctrine of merger, and it's antitrust law. But we're going to go down here to the merger of doctrine, trust law. Now, I want you to notice too that there's a merger of doctrine for property law, family law, copyright law, civil procedure. In essence, it's the same thing, but I want you to understand that there are a lot of different terminologies for different types of laws, or sometimes they're the same terminologies for different types of laws. So be specific when you're doing trust studies, what I'm trying to say here. All right, when you look up one thing, or when you hear one term and you don't understand it, look it up, but make sure it applies to trust law. All right, so we're going to go down to the merger of doctrine, trust law. All right, in the law of trust, the term doctrine of merger refers to the using of legal and equitable title. Okay, boom. So this right here is the proof of the title split. In the event the same person becomes both the sole trustee and the sole beneficiary of a trust. In such case, the trust is sometimes deemed to have been terminated, with the result that the beneficiary owns the trust property outright. So now what they're speaking of here is when they say, what happens if when you have the doctrine of merger, when someone is guilty of the doctrine of merger, or they violate the doctrine of merger, meaning they've merged the title, right? It refers to the fusing of both titles, legal and equitable, is when the same person becomes both the sole trustee and the sole beneficiary of a trust. So, if a grantor deems himself or herself the grantor and beneficiary, because we mentioned this earlier, that the grantor cannot be the sole beneficiary. The grantor can be a beneficiary in a statutory trust, but not the sole beneficiary. Because if the grantor is the sole beneficiary, then how is the title split? That means the grantor owns the property and the grantor gets to use the property. That is not a trust. The trust happens when the titles are split. One person has legal property, or I'm sorry, legal title, and one has equitable title. All right, that is when you have the trust. So I hope that was made clear. And when you merge the two, you don't have a trust. That's why they say the trust is deemed to have been terminated once the legal and equitable title have been merged. Once one person owns both legal and equitable title. All right. So now, this family concludes Module 2, and we will proceed to Module 3.